special chairman's update and a great guest, Pete Serrano, who's running for state attorney general. He's our endorsed candidate for state attorney general and was just in court today over in Seattle on this ACLU lawsuit against the Washington State Parents' Bill of Rights that we passed into law in the last legislative session. It started out its life as Initiative 2081. It was one of the 6 initiatives that we qualified last year and one of the 3 that we passed through the legislature into law earlier this year. So it's law. The ACLU is challenging it, representing a bunch of left-wing organizations, and Pete has been representing both me personally as the author of 2081 and also a group of parents' rights and more moderate groups trying to defend that new law. So Pete, really, the floor is yours. Update us on what happened.
Yeah, so today I came in, as you mentioned, representing you, Let's Go Washington, Informed Choice of Washington, and One Washington. And we sought what's called intervention status. That's, hey, we are affected by this bill, not just as parents, but as people who invested in the passage and the adoption of this bill and its implementation. And the judge granted us that status. So you're now actually a member of the lawsuit, not just the guy that's hopeful. Right. Yeah, we'll just tee it up, Jim. Just another one on the board. And so the question today before the court was whether or not he should enjoin this on a preliminary injunction. And I'm going to give you 2 words here. Enjoin is to put a pause on or a stop, and a preliminary injunction is a temporary one while litigation is pending, and it might be, decided really quickly after the injunction that we had today. So the judge issued an injunction on 2 elements of Initiative 2081 and then kept the rest intact. And I want you to frame on that last part. I will talk about what's been enjoined. 1, the 10-day notification. The bill had a requirement that any records requested by a parent would be distributed to that parent within 10 days. Under federal law, it's up to 45 days. The judge says there's a conflict. So he said, well, we're going to at least use the 45-day, but it's also as soon as possible. So it doesn't have to be 45 days. So there's that.
And we knew there was a tension on how long the school or the institution could hold information. Under FERPA, under the federal law, as Pete says, they can go to 45 days. We knew 2081 said 10 days. We knew there was tension there. So this was not surprising. We like our 10 days better, but we understand that.
Right. There's always what you want and what the court's going to give you. And then the second issue that he enjoined was there's not a natural right to have your kids' mental health care or other physical health care records. So that's presently on pause, which I know is significant concern. I do want to note, concerns there I understand, but the opt-out clauses, those things all remain intact. And what that means is when your kids go back to school in 2 or 3 months, unless they're on all year round, that those are going to be in play. You're going to be able to opt your kids out, and you should have a more robust opt-out program that hits your door sometime between now and then.
And the second thing that the judge paused is a bigger deal to me, and I think to most of us. Basically, he's holding up the so-called mature minor doctrine in our state. That's other law, existing state law, and he's putting that above this piece of law. And that's a bigger tension. Again, not a surprise. We knew there was some tension there, but that's a bigger deal. And I think that's going to be a bigger part of the ongoing lawsuit.
Oh, absolutely. I mean, I think, these are going to be the 2 real ripe elements that are going to get traction throughout this litigation. But absolutely, I think whether or not a parent has the right to their child's mental and physical health evaluations is absolutely proper for the court to decide. And I'm looking forward to getting into the weeds on that.
And it's important to, as Pete said, it could have been worse in that the judge could have put a pause on the whole thing, on the Parents' Bill of Rights entirely. He didn't do that. He narrowly focused on 2, what are probably the most contentious pieces of it. Understandable. I don't like what the judge did, but it is rational that he narrowed the focus of the pause on those parts of it, leaving most of the Parents' Bill of Rights in place and in effect and in good law. And I think that's a win.
Yeah, well, absolutely. There's no question. I mean, the fact is he could have not let us in, right? I mean, so we've got people who are advocating for you in addition to the state, and they did a good job. I will give the state credit where it's due. The state did a good job today. And you have us also making sure that it's in your favor, not the ruling, but certainly the litigation. And we could have lost the whole enchilada today. Absolutely could have lost the whole thing, and we did not. I understand the importance, especially of the records. I get it. I don't like it either, but at the end of the day, we won the rest of it aside from that in the 10 days. So I think this has a really great traction for the summer and fall.
Good. And remember, this is just the temporary order pending the outcome of the actual lawsuit that the ACLU has filed against the state. This is a strange bedfellow situation. We're actually allied with the current state attorney general, the guy that Pete wants to replace, on this issue, because the state attorney general is defending I-2081, the Parents' Bill of Rights, as standing law. So it's going to be obviously something that positions Pete very well to take over as AG, and continue this defense perhaps, later this year, early next year. But Pete, the other thing I wanted to talk about was the related issue where the current school superintendent, Reichel, has told schools to disregard the Parents' Bill of Rights. Seems to me that this court ruling undermines his position to say that. It's already a bad thing what he did, but I think this really underscores that he can't be telling schools not to follow the law. What's your take on that?
Yeah, absolutely. I mean, if anything, he needs to reissue a statement that said, "Hey, here's what happened in court today," and I suspect the attorney general's office will advise him accordingly. We'll say, "Here's what happens today. Here are the two elements that there's a pause on. You don't have to comply with those, but the rest of it, you do have to comply with." Now, if we don't see that from Reichdahl, I think he's going to have some serious issues.
Well, that's it for today, Pete. Thanks so much
Absolutely.
for being there in Seattle in that courtroom fighting for us. A special update. There's going to be more to tell in the coming days and weeks. In the meantime, stay strong and be well.